Thank you, Mr. Chairman, and to the ranking member, I so appreciate the fact that you've convened this hearing today to take up what I believe we all agree is an important issue, and that is as we explore whether our federal prosecutors are meeting their discovery obligations. It's an important issue for this committee to pursue as it goes directly and intimately to the question of whether federal criminal defendants are being treated lawfully and consistently by application of divergent Brady practices across the various judicial districts here in the United States. I'm hopeful that this oversight hearing will be followed in the near future by a legislative hearing on the bill which you have addressed, which is S-2197. It would establish uniformity in compliance with the Brady obligations. It would establish uniformity basically in three different ways: the what, the when, and the how if Brady is not complied with. So with respect to the what, S-2197 would eliminate the materiality requirement as a matter of statutory law and end the practice through which prosecutors rationalize their way out of disclosing material evidence by claiming that it's not material. With respect to the when, the legislation would direct that prosecutors disclose Brady and Giglio material as early in the process as is feasible. And this would enable both sides then to evaluate the merits of the cases and promote appropriate and efficient dispositions. And then finally, S-2197 provides trial judges with a broad range of remedies that can be employed if Brady obligations are not obeyed, and the confidence then to use them. To appellate courts, what it does is send a strong message that the Brady obligation is mandatory, it's not optional, and that the harmless error rule should be used sparingly when evaluating breaches of the Brady obligation. I believe that the legislation strikes an appropriate balance between competing interests, in particular with respect to the issue of witness intimidation and protection of classified information, which Senator Grassley has raised. The bill has been endorsed by a pretty broad and wide-ranging group, well-respected groups. We've got the American Bar Association that has supported it, the American Civil Liberties Union, the U.S. Chamber of Commerce, so clearly coming from divergent perspectives, but all in support of this legislation. Now, of course, the bill does have its detractor, most notably the U.S. Department of Justice, and I'd like to take a moment to address my concerns with their approach taken to the legislation. It's been widely reported in the legal press that the Justice Department has historically opposed efforts to establish a uniform Brady process. I've consistently said that Congress is perhaps not the most desirable of places to deliberate on Brady reform. Ideally, these issues would be sorted out by the Advisory Council on the Federal Rules of Evidence. The Justice Department would have us believe that the Advisory Council has considered Brady reform on its merits and then rejected it. But the legal press indicates that the Advisory Council's reform efforts have been abandoned as a direct result of the Justice Department opposition. Now, I'd also like to comment on the superficial approach that the Justice Department has taken to its evaluation of the legislation. The Department first criticized the bill in the press after it was introduced and subsequently in hearings before the House Judiciary Committee. The Justice Department would have us believe that this legislation somehow is going to open the jailhouse doors, let the criminals, let the terrorists all run free. Precisely the same sort of superficial arguments that are used so frequently to argue that searches conducted and evidence seized in violation of the Fourth Amendment should be excluded, precisely the sort of argument used to argue that the Miranda rule should be eliminated. Now, under our system of justice, the victim has rights, the government has rights, and the defendant has rights. And one of the defendant's rights is the disclosure of exculpatory evidence in the hands of the government. Another of the defendant's rights is access to information suggesting that a government witness might not be forthright and truthful. The government's interest in prosecution is balanced then against the defendant's interest in a fair trial. In this instance, the government would have us ignore that the defendant has rights which need to be uniformly administered. And that's how the government got into the Brady mess that it presently finds itself in. As this committee heard from Mr. Schulke, prosecutors from time to time exhibit a contest mentality which gets in the way of their judgment with respect to the rights of the defense. And that's why I think it's important for Congress to speak to the obligations with a single and enduring voice. A criminal defendant's rights should not depend on whether or not Mr. Holder or someone else is the Attorney General, or whether the Attorney General comes from one party or another. The obligations and the rights should be uniform, they should be predictable, and they should be consistent. And as you have noted, Mr. Chairman, it shouldn't make any difference who that defendant is. Now, I would also acknowledge that some would argue that S-2197 is not sufficiently protective of the interests of defendants. These experts would have us go to an open file system of discovery. I do think that there are merits to this approach, provided that the exceptions don't swallow up the rule and discovery is provided sufficiently early in the process to then be meaningful. My suggestion to the Justice Department is that they express a willingness to work with me and the committee on a set of unified Brady practices that can be legislated. If the Justice Department thinks that S-2197 is not sufficiently balanced or protective of some interest or another, perhaps they could propose a concept that would make it more balanced. But I'm sad to say that since my legislation was introduced in March, I've had no direct contact from the Justice Department until yesterday, when Mr. Cole did call me to discuss this hearing. But I think that that suggests that the Justice Department doesn't take this effort seriously. And if that's the case, it suggests that this is somewhat of an arrogant or a dismissive approach, and I think that's unfortunate. I would respectfully submit that the Justice Department is in no position to be arrogant. The latest chapter in the Ted Stevens prosecution demonstrates that beyond a reasonable doubt. Every time I read a post-mortem on the Stevens prosecution, I am left more and more convinced that it was fatally mismanaged from the get-go. And the Justice Department's unwillingness to stop it from going to the jury, despite the many red flags that justice had not been done, I think is unconscionable. The Office of Professional Responsibility report released in late May reveals that there was considerable doubt as to whether the Justice Department would go forward with the indictment. Once it did go forward, it's evident that the case was mismanaged from the very top to the very bottom. Senior public integrity section managers were more interested in the egos of staff attorneys passed over for first chair responsibilities than seeing that Brady was carried out. Brady obligations were delegated to law enforcement officials who were neither properly trained nor supervised to carry out their responsibilities. There was poor communication between Washington and the Alaska attorneys that were working the Brady issue. And in spite of all of these deficiencies, the Office of Professional Responsibility offers only a slap on the hand to one senior official in Maine Justice, that would be Ms. Morse, who was responsible for supervising the case, not anything directed towards her boss. I would also note that while Mr. Schulke found that the Brady violations committed by 2 members of the Alaska U.S. Attorney's Office were intentional, the Office of Professional Responsibility simply discards this finding. And the reason, I think, is obvious. The Office of Professional Responsibility never once considered Mr. Schulke's findings. Its report was issued August 15 of 2011, about 90 days before Schulke's report was completed. I can't understand why the Office of Professional Responsibility did not go back and reconsider its report in light of Schulke's conclusions. The public deserves to know whether the Office of Professional Responsibility concurs with each of Schulke's conclusions or does not, and why. The Department's plans to expeditiously close the books on this unfortunate episode will prevent the people of Alaska from ever reaching closure on this issue. The Ted Stevens prosecution was one of the most sensitive and probably one of the most delicate, one of the most important prosecutions that the Justice Department has ever undertaken. And I say this because few prosecutions cut as close to the relationship of the American people to the government as this one did. If the Justice Department is going to allow a case involving a sitting senator seeking re-election to go to a jury weeks before that senator's general election, it must be absolutely certain that the defendant's rights were meticulously observed. In other words, if the Justice Department had the slightest doubt that it conducted its trial in the fairest fashion it should have asked for, it actually should have demanded a mistrial. With 2020 hindsight, there is no question that this case should never have gone to the jury. And with 2020 hindsight, it's now evident that the right of the people of Alaska to select a senator of their choosing was interfered with by the Justice Department's malfeasance that permeated every aspect of this prosecution. This is truly one of the darkest moments in the Justice Department's history. I've said that before. We're no longer able to do justice to Senator Stevens, as he was defeated and then died less than 2 years later. But we can, through legislation, through reforms, make a start in ensuring that the same fate does not befall other defendants. Mr. Chairman, I thank you for your attention to this issue and look forward to working with you and members of the committee.